So Chapter 12 covers field interviews, arrest, and jail searches. So when we have the right to use force, that force has to be reasonable enough in order to effect an arrest or detention. It should be proportional to the threat faced, and deadly force is restricted in its use. Non-deadly force is also limited but has fewer restrictions. So things we want to look at here are the person, the appearance, and the force used when we're determining whether or not the force was excessive. So we mentioned Tennessee v. Garner towards the end of the last chapter, and this is a case from 1985. The police shot a suspect who was fleeing the scene of a burglary. The police at the time knew he wasn't armed and knew he was nonviolent. So the Supreme Court placed limits on when deadly force can be used. Basically, a fatal shooting is the ultimate seizure under the Constitution, and police should only use deadly force when the totality of circumstances lead them to believe it's necessary. So the suspect at which you are shooting should be in immediate physical danger to the officer or an innocent civilian. In 1989, in Graham v. Connor, Graham, a diabetic, was arrested and sustained multiple injuries when the police took him into custody. Here, they decided that the objective reasonableness standard applies to all arrests. You don't have to show that the harm was intentional or malicious. You're looking to make sure it's reasonable based on the situation. So, what's a reasonable level of force? Well, first, it depends on the person, right? It depends on the suspect and the police officer. So, if you've got a very, very tiny person. One person is very tiny and one person is large and muscular. That's going to change how much force the tiny person could use, right? They'd be able to use more force because their opponent or their suspect, is bigger than them. We also need to look at the perception of danger, even if the real danger is limited. We're looking at how does it appear in the moment. And deadly force is only allowed if police or the public, either the police are in danger or the public are in danger of death or serious injury. And any force used must be reasonable. When we're detaining someone, the force used to effect that arrest is based upon probable cause for the arrest. So this means the crime, the victim, and all the circumstances are important. Excessive force could result in criminal charges against the police or a civil lawsuit. In a field interview, we're briefly detaining someone to question them. So what are the standards then for temporary stops, temporary detentions? Well, we have a Terry stop, right, where the police have an articulable suspicion of a crime. So something that they can explain to someone else why they suspect a crime is afoot. Then they can detain a suspect and question them briefly. We also know that with a Terry stop, they're allowed to pat somebody down for weapons only in order to ensure officer safety. In order to detain somebody, we need reasonable suspicion of a crime, not mere suspicion of a crime. And again, you have to be able to articulate those facts. So in Terry v. Ohio, the police noticed several men are acting nervous in front of a store. Officer McFadden had been working the streets for many years, and he thought that they were casing a store in order to rob it. McFadden stopped them, patted them down, and found weapons. The court found these types of stops with pat-downs for weapons are constitutional so long as the search is non-intrusive. So when you pat somebody down, you need to be able to feel from the pat-down that the item that is on them is a weapon. If you then find a weapon, that's a legal seizure. So again, when we're talking about a temporary detention, the courts haven't said X amount of time is the maximum amount of time, but it generally needs to be brief, minutes, not hours. As I mentioned, the search is limited to a pat-down for weapons, and we can't use other evidence discovered to justify the search. So we can, under special situations, request identification from a suspect. Car stops are a little bit more limited, so there's some types of roadblocks that are permissible, and stops for minor violations are permissible. We cannot compel somebody to give us their fingerprints unless they're under arrest. And we don't need to Mirandize someone unless they're under arrest. So if I walk up to the police and I start telling them about crimes I've committed, right, I'm not under arrest. So there's no need to Mirandize me. Same thing if I place you under arrest, but I'm not going to interrogate you or ask you about the crime in question. I don't need to Mirandize you. In terms of searches in schools have far fewer rights, okay, students in a public school. So searches by school staff have fewer restrictions. Basically, you're looking at the special needs of the school to maintain a safe environment. Canine searches, a brief detention for sniffing by a dog is not considered an arrest, and you cannot hold someone for a prolonged period. Remember that an arrest is a seizure, and so it has to have probable cause, not just mere suspicion. You have to be able to show probable cause for each and every element of that crime. If after arrest they want to question somebody, now you need to Mirandize them. So you need to tell them their Miranda warning rights. So Miranda v. Arizona is a case from 1966. It actually involves several people besides Miranda. But Miranda's arrested and brought into police custody. They don't tell him, prior to this, the police weren't telling you about your rights. So unless you knew that you had the right to remain silent, you wouldn't know that, okay? You wouldn't necessarily know you could request an attorney, even if you couldn't pay for one. So the Supreme Court said that when suspects are being questioned, they have to be made aware of their basic rights: to remain silent, to have an attorney, and to have an attorney appointed at state expense if they cannot afford one. So everybody who's watched TV and, since Miranda v. Arizona knows their Miranda rights. In order to arrest somebody, the police need probable cause to arrest for a felony if they don't have a warrant. For misdemeanors, they need a warrant, or the crime has to be committed in the presence of the police. Some states do allow citizens to effect a citizen's arrest. A warrant allows an arrest in any situation. So whenever possible, you want to get a warrant, especially if you're arresting someone in their home. Okay, so when we arrest somebody, we can also conduct a search incident to arrest, okay? And that is to protect the police from harm, very similar to when we stop somebody and we pat them down. It also prevents somebody from destroying evidence. So the older rationale was to protect the police, to prevent destruction, and allow seizure of contraband. Today, the standard is limited to the area under the suspect's control. We want to make sure the suspect can't reach for a weapon and harm somebody. So here we've got another little diagram here, right? So we're going to arrest this man here. Where can we search? We can search, you notice, just these areas under his immediate control. Where can he reach and grab something? Anywhere else we want to search, we need to go and get a search warrant. So this comes from Chimel v. California in 1969. The police were arresting somebody in their own home. And so they conducted a search incident to the arrest. Okay. The Supreme Court limited the search and said the officers could only search the petitioner's person in the area from within which he might have obtained either a weapon or something that could have been used as evidence against him. Oops, wrong way. So in a search incident to arrest, we can basically search the area under their immediate control for weapons and contraband, regardless of the crime for which they're being arrested. We can't use items found to justify the arrest, though, so we have to already have a reason to arrest them. Arrest searches can be more intrusive than a frisk, and whatever evidence is found is admissible, even if it's not related to the arrest. If we're just dealing with someone who's getting a ticketable offense, the search is more limited. And we're going to look for the state statute to determine where you can search. In terms of a vehicle, you can search the whole compartment if arresting the driver or the passenger, and the search here can be quite intrusive. And we're going to talk about that in a future chapter in a little bit more detail. And again, for a protective sweep, we're doing a quick visual check of a larger area for any safety concerns. What about when we book somebody? So when we're booking someone, we're admitting the arrestee to jail. So again, we have a search that's permissible here, and it's limited to the person and their property because we want to prevent any weapons or contraband from entering the jail. The search of the person can be extensive and usually involves a strip search. For a minor offense, there may be some limits to this. Anything in their possession is subject to search. In terms of jail and prison, once we're in physical custody, all searches are permissible. Okay, they're based on any reasonable administrative reason. People can be intensively searched. There's no expectation of privacy in your cell, so it's open to any warrantless search. So remember, when you go into jail or prison, your Fourth Amendment rights are limited because there's no reasonable expectation of privacy there. Okay, and that wraps up Chapter 12.